Can an estate planning attorney who prepares trust and will documents be sued not by the client or personal representative of the estate, but by a prospective beneficiary? To find out, you have to read Phillips versus Murtha, but it's 2 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the recent case of Phillips versus Murtha. The citation for this case is 2015 AD 3rd 408 out of the Appellate Division First Department, published by them on April 4th, 2023. The issue in this case is whether prospective beneficiaries and beneficiaries under a will can sue an estate planning attorney for malpractice, even though the client is deceased. To find out a little more about this case, to appreciate the background, I think it's helpful to know that privity is the concept that there has to be a direct relationship between parties sufficient that a party owes a duty to another party and can be sued for a breach of a duty to that party. So privity is that relationship between parties that are that owe each other a duty or obligation and therefore can be sued for that failure to comply with that duty and obligation. And you should know that another case I had done, another video I produced, is the case of Schneider versus Finmann. It's a case out of the Court of Appeals from 2010, and it talked about how the general rule requiring the strict privity rule requiring that there be privity between parties that are suing each other for breach of fiduciary duty or breach of obligation, such as malpractice. That obligation for privity was changed in that case of Schneider versus Finmann. It allowed the personal representative of an estate, of a deceased person, to sue the estate planning attorney, the will drafting attorney, for breach of professional duty, otherwise known as legal malpractice. Before that case, you couldn't, because the privity was between the attorney and the client, who was now dead. But that case of Schneider versus Finmann said that the personal representative for the estate has sufficient privity such that they can sue for malpractice. But the general rule of strict privity applied for everybody else, and that brings us to this case. The facts here are that the primary plaintiff is Jessica Phillips, who's a beneficiary and prospective beneficiary of a will. Michael Murtha is the drafting attorney, the estate planning attorney for the deceased person who had the will. Murtha prepared the will for his client, who's now dead, which left a substantial amount of money to Jessica Phillips, the plaintiff. But he also prepared trust documents, which left the bulk of the estate to a caretaker, who is not Jessica Phillips. So after the decedent died, after the person who had the will died, Jessica Phillips sued the attorney, drafter, for malpractice and for negligence. The attorney moved to dismiss, said, I don't owe you a duty. I don't have privity with you. And the judge in that case, Judge Barbara Jaffe, dismissed the case, said no privity, no obligation, dismissed for failure to state a cause of action, and no privity for malpractice. The plaintiffs appealed, actually moved to renew and re-argue. It was denied. They then appealed to the First Department, and that's this case. And the First Department then goes through that strict privity rule and says there is no duty owed by an attorney to prospective beneficiaries or beneficiaries of an estate. Of the 2 possible actions, legal malpractice, right, against the attorney, or simple negligence, the legal malpractice only applies if there's privity between the client or, as Schneider versus Finmann said, the personal representative of the estate. Here, the plaintiff here, Jessica Phillips, is neither of those people. And absent fraud, collusion, malicious acts, or other special circumstance, those are the only exceptions, nobody else has privity and therefore can sue for malpractice. So the malpractice action is gone. And as to regular negligence, Jessica Phillips, the plaintiff here, did not sufficiently allege, didn't plead, because the facts aren't there, presumably, that there is a direct relationship between the attorney and the plaintiff. And without that privity, without that duty, then you don't get the duty, breach, causation, and damages, which are the elements of a basic simple negligence case. So the key quote in this case is the relationship between an estate planning attorney and a prospective beneficiary under a will and or trust does not in and of itself give rise to a fiduciary duty owed by the attorney to the prospective beneficiary. So the rest of that general principle of no privity, then no malpractice still applies with respect to prospective beneficiaries. And that's the recent case of Phillips versus Murtha. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.